Welcome back to another Explainer. Today, we're diving into a completely fascinating constitutional court case about a town that literally went to sleep in one province and woke up in another. We are looking at the landmark South African legal battle surrounding the Matatiele Municipality. It's kind of wild to think about, right? I mean, can the government just move your town to another province without even asking you? Just imagine waking up one day and finding out the very borders of your province have been magically redrawn around you. Suddenly, your home, your kids' schools, and your local government are under an entirely different administration. And the kicker? Nobody bothered to ask for your opinion. Well, this exact question is the central legal drama of the Matatiele Municipality case, and as you'll see, it seriously tests the very limits of how laws are made. Section 1. The Town That Moved. So let's go back to late 2005. The South African Parliament adopts the Constitution 12th Amendment Act. Basically, this piece of legislation fundamentally altered how provincial boundaries were determined. Instead of using the old system, which was based on magisterial districts, the government decided, you know what, let's redraw the map using municipal areas instead. Now, on paper, that just sounds like a simple administrative update, right? No big deal. But in reality, it meant that the geographical borders of 7 out of the 9 provinces in South Africa had to be shifted. And if you take a look at this before and after, you can see this specific, really abrupt shift for the community of Matatiele. Before this amendment, their local municipality was sitting securely right inside the KwaZulu-Natal province. But after the 12th Amendment passed, they were legally relocated across provincial lines and absorbed into the Eastern Cape province. Now, obviously, they didn't physically move. They were living in the exact same houses on the exact same streets. But legally and administratively, they were completely transferred to a different provincial government. So, how does something like this just happen? Well, that brings us to Section 2, the rules of the game. Now, you might be wondering if there's a rule against this, and yes, the system actually has a built-in constitutional protection. Section 74 of 8 of the South African Constitution says that if a proposed amendment alters a specific province's boundary, it cannot be passed unless it's approved by that province's legislature. The Constitutional Court actually calls this a bulwark of provincial integrity. Basically, you can't just shrink a province against its will. So for this to be legal, KwaZulu-Natal absolutely had to approve the loss of Matatiele. But wait, there is a second, equally important rule here, Section 118(1)(a). This rule mandates that a provincial legislature must facilitate public involvement in its legislative processes, meaning they can't just take a vote behind closed doors. They are constitutionally required to actually talk to the people affected by their decisions. So before KwaZulu-Natal could even think about approving the loss of Matatiele, they had a strict duty to get the public involved. So what actually happened? Section 3, the missing public voice. If you look at how the two provinces handled this, it's honestly like night and day. The Eastern Cape recognized how huge this bill was, so they held 7 public hearings across rural and urban areas, they took written submissions, and they genuinely engaged with the public before officially supporting the amendment. But then, look at KwaZulu-Natal. 0 hearings. Literally none. The KwaZulu-Natal legislature completely failed to hold a single public hearing for the people of Matatiele before just handing over their mandated support. And, this wasn't just some harmless paperwork error. Justice Zigobo, writing for the Constitutional Court, really recognized the intense emotional impact this unconsulted move had on the locals. He noted, and I quote, "There are natural sentiments and affections which grow up for places, attachments to province, to home, and to family." By completely failing to talk to the community, the legislature just ignored the real-world impact of their decision on these citizens. Citizens who absolutely had the fundamental right to remain in the province of their choice. So why on earth did the government think they could just skip this step? Section 4. 2 types of democracy. Okay, so when they get challenged in court, the government lays out this very specific defense. First, they argued that the 12th Amendment was a national bill, so the provincial rule for public involvement didn't strictly apply. But more importantly, and this is the fascinating part, they argued that because the provincial legislature is made up of elected representatives, those officials automatically speak for the people. In their view, holding direct local hearings was completely unnecessary because the people had already spoken by electing them in the first place. But the Constitutional Court completely disagreed with that narrow view. They looked at the South African Constitution and clarified that, hey, we're not purely a representative democracy where elected officials just make laws in a vacuum. The Constitution also contains vital elements of a participatory democracy where citizens actively engage in the process. And these two concepts, they aren't fighting each other. They're designed to work together. Elections are just the foundation, but continuous public participation is what actually gives life to the democracy. And this matters so deeply on a human level. Justice Nkobo hit the nail on the head when he wrote, "Participation is necessary to preserve human dignity and self-respect." Giving citizens a voice is not just about checking a box on some bureaucratic form, it's about preserving their dignity. It ensures that when a government makes a monumental decision like, moving a whole town to another province, the people whose lives are actually disrupted get to be heard. Section 5. The court's final verdict. So, the Constitutional Court drops an absolute bombshell. They rule that because KwaZulu-Natal skipped the public hearings, they acted unreasonably and violated Section 118(1)(a. And because they broke that rule, their approval of the amendment was invalid, which means as a direct result, the entire part of the 12th Amendment that transferred Matatiele over to the Eastern Cape was unconstitutional and completely invalid. Okay, but here is the massive elephant in the room. What happens to the elections? Because the court's ruling came down in August 2006, right? But a massive nationwide municipal election had just taken place on March 1st of that same year, using the new provincial boundaries. Section 6. Avoiding electoral chaos. You can see the immediate, real-world disaster brewing here. If the court just voided the amendment immediately, those March elections would instantly become completely invalid. Matatiele would snap back to its old borders, sure, but it would have zero legally elected municipal government. No one to authorize welfare payments, no one to run health services, no one for education. It would be an absolute administrative nightmare, and it would require at least 6 months of incredibly expensive redemarcation just to hold fresh elections. So to prevent this chaos, the court does something really clever. They used a unique constitutional power to create a ticking clock. They declared the boundary change unconstitutional, yes, but they suspended the order of invalidity for 18 months. Basically, they hit the pause button. This kept the current municipalities temporarily legal, but it gave Parliament exactly 18 months to go back, actually facilitate proper public involvement, and pass a new constitutionally valid amendment. So it leaves us with this huge question. Will Parliament beat the clock to consult the people, or is electoral chaos inevitable? That was the incredibly heavy burden left on the government's shoulders by the court. And honestly, it is such a powerful reminder that in a true democracy, efficiency can never, ever come at the cost of the public's right to be heard. Thank you so much for joining this explainer as we broke down the constitutional mechanics of the town that moved. Keep asking those big questions, and I'll see you in the next one.